I'm the medical director of the Natural Solutions Foundation. We are dedicated to the very simple proposition that you own your body. No government owns it, no corporation owns it, no fascist-fused entity of corporate state owns your body. And if you want clean, unadulterated food or air that has not been sullied with poisons or non-GMO products and foods in your life, or if you want to be vaccine or drug free, if you want to be free of radiation zapping your DNA, then you have that right. It's called health freedom, your first and most fundamental right, the right to determine what happens to your body. My point is that we have these rights. The CDC at the moment, and we'll be talking about that with our wonderful guests. I'm so pleased to have them on, and I'm so pleased to have them together. Catherine Frompovich and Larry B. Kraft, two of my very favorite, intelligent, activist commentators and thinkers on matters of health freedom. We are facing a new level of medical tyranny from the CDC. We have about a month to bash it down by the strength of our numbers, saying the three most important words that an activist can utter. And those words are, don't you dare. And we have to say that to the CDC in our millions. And we'll be talking about what it is that the CDC is doing and why they are doing it and how it affects you. How it affects you, my friends, if we do not succeed in smashing this latest atrocity, a violation of health freedom down. How it affects you is cataclysmically, because you become pharmaceutical chattel property to the state. So do your children. Let us move to the discussion of the newest round of medical tyranny and atrocity.
So I thought, if the guests would not mind, I would basically read about 5 or 6 paragraphs that will set the tone. It actually has quotations from the regs, and I know Larry always wants us to look at the actual words, and that's important. I want you to start with our comment. It was submitted to the CDC as part of the requirement that the government has of receiving the public's comments before making new regulations. In an audacious violation of national and international law, the Centers for Disease Control, the CDC, a part of the Health and Human Services Department of the United States government, proposes the adoption of a regulation giving it power to quarantine and force treatment, vaccination, for certain unspecified quarantinable diseases. The proposed regulation brings medical tyranny to a new level of danger by specifically overriding any and all informed consent rights, despite the well-established legal right to informed consent. We must ask what diseases CDC has in mind. Measles, a non-quarantinable and trivial disease, is mentioned 186 times in this regulation and introduction. Ebola is mentioned 330 times. Influenza, another non-quarantinable disease, is mentioned 26 times. We're going down. And Zika, interestingly enough, is not mentioned at all. In context, generally mild self-limiting diseases like measles are irresponsibly and irrationally equated to deadly diseases such as Ebola. The regulation permits the CDC to include any communicable disease. A close reading of the proposed regulation shows the word consent is mentioned 12 times, always in the context of denying the individual right to consent. Sections 78.18 and 71.40 are two specific sections in which this occurs. These two sections are about entering into agreements. What it says is that CDC may enter into an agreement with an individual. Remember, informed consent is actually about agreeing, right? Upon such terms as the CDC considers to be reasonably necessary. This is, as Larry would say, I guess, a contract of adhesion. One side writes it, the other side either says yes or no. But in this case, may be reasonably necessary, indicating that the individual consents to any of the public health measures authorized by this part, including quarantine, isolation, conditional release, medical examination, hospitalization, vaccination, and treatment. And then it goes on and it says, provided that the individual's consent shall not be considered as a prerequisite to the exercise of any authority under this part. Very clear. There is no language in the proposed regulation that actually safeguards the right to informed consent. And then I go on in this particular article that we submitted to the CDC to quote from the Nuremberg Code and the UNESCO Universal Bioethics Declaration, to which the U.S. is a signatory. It's very clear that this is a violation of informed consent. And so what we've done is we've set up one of our action items, web form action items, so that people can tell the decision makers, their representatives at state and federal level, CDC, FDA, the usual gang of suspects, I do not consent, and I want my legislators to adopt laws that will protect my right to informed consent. And you can find that at tinyurl.com, informed consent protection. That's on the screen, of course. tinyurl.com, informed consent protection. And that's the background, folks. That's where we start from. And we have a brilliant investigative journalist, an eminent attorney at law. Indeed, some of us have called Larry B. Kraft the Dean of the Patriot Lawyers. Larry, do you want to start with any comments you have on the question of domestic, interstate, and foreign?
Yeah, Ralph, I think there's an interesting problem that we have here with these new regulations that you've been discussing during the course of this program. Last week, I came home late at night reading my email, and I saw all this stuff talking about regulation. Read some websites that were discussing this particular problem, and then I started a brief examination of those regulations. I think that we have a real problem here from our viewpoint about perception. The only way that you can get down to understanding the reach and scope of CDC and anything at the federal level dealing with health matters, we need to go back into history. First and foremost, the direct control of medicine, the practice of medicine by the federal government is outside the scope's powers. And indeed that is the case because the powers of Congress are outlined in Article 1, Section 8 of the United States Constitution. And there's nothing there about regulating the practice of medicine. So that's one field that must be understood when you try to understand the reach and scope of all of these laws regarding vaccination, the proper role and purpose and function and jurisdiction of the CDC. Now, let me go back a little bit in time. That I have spent a tremendous amount of time dealing with, what is the subject matter jurisdiction of federal agencies? What is the reach and scope of federal legislation? What role does a federal agency have in enforcing federal laws? If you go back and take a look at the old history, the way that Uncle Sam gets any authority over the control of diseases happened long ago at the ports of entry. You would have people coming from other countries, and they may very well be coming into this country with some type of communicable disease. There has been historically a background for the development of these federal agencies like the CDC. Now, with that background in mind, last week when I started looking at those regulations, they're talking about reaching to the fullest extent of the interstate commerce power of Congress. I would suggest to you that the real parties that are subject to all that are not going to be American citizens, but are going to be foreigners.
So you think that this entire regulation is really aimed at foreign nationals?
So it's controlling the ports of entry.
However, if you don't do that and you only take a look at current legal materials like statutes and regulations, you're missing the limited purpose for a law that manifests itself when you're dealing with the older materials.
Well, now, if CDC manages to promulgate this regulation and it becomes a final regulation, which, folks, has the impact of law. So a regulation is not a suggestion. It has the strength of law. If that happens and the CDC somehow, without making it explicit, intended this to be non-U.S. citizens, and I actually have trouble believing that that's what they meant, but they didn't put it in there, would they then have the right as this regulation is worded, to apply it to U.S. citizens?
Well, Catherine has delved into this issue, and I think it's time to hear from her and her perspective. She's one of the people who really raised the alarm that led us to doing what we're doing. Go ahead.
Thank you very much for inviting me on. I appreciate it. First, I would like to say, listening to what everybody had said, I think I'm going to bring a different spin on my interpretation of what is possibly going on. First of all, I am of jaundiced eye and opinion enough to think that this could possibly be some sort of a Trojan horse. And I'll tell you why. In reading through that proposed mammoth rule, the CDC has deliberately gone about redefining the definition of what an ill person would be. This is all, in my opinion, a fear campaign. Now, it's very interesting that they have redefined everybody who they're going to say is able to be classified as a sick person. Well, children who have asthma, what are they going to do with them? Are they going to be
very simple. They're going to vaccinate them. These are such broad categories, and they occur in so many things that have nothing to do with bacterial, viral, or other diseases, that it's astonishing. And it empowers not only crew members, pilots, bus drivers, it empowers basically everybody not only to be doing the Ashcroft see something, say something spy dance, but to be evaluating everybody's health all the time. Oh my God, that kid over there coughed. Call the CDC guys. What craziness.
All right, and can I give you something else that's very interesting from the text that rang a bell for me? There's a thing that they're calling pre-communicable stage. The stage beginning upon an individual's earliest opportunity for exposure to an infectious agent and ending upon the individual entering or re-entering the communicable stage of the disease, or if the individual does not enter the communicable stage, the latest state at which the individual could reasonably be expected to have the potential to enter or re-enter the communicable stage. What does that tell you, my dear friends?
What that says is anybody, anytime, for any reasons, can be swept into one of these bizarre, absurd, insane, illogical, garbage bin categorizations, and then can be forcibly detained and treated, including vaccination. Anybody can be swept up and involuntarily assumed to have made an agreement which does not require their assent, and then treated in whatever way is suitable or good or desirable to the CDC. And there is nothing here that says that the treatment needs to be good for you. In fact, let's say that you are susceptible to X, Y, or Z component of whatever treatment is offered to you. And let's say that that treatment is given to you and it makes you sick or it makes you dead. Oh, well, the purpose of these regulations was not to assure your health anyway. Larry, Catherine, Ralph, do I see this correctly?
I would agree with you, and that's why I brought this into the conversation, because I believe it's a dragnet. Can I offer one more thing out of the proposed ruling?
Of course.
We could even gild the lily further. When apprehended and taken into custody, the person will be forced to be treated medically, including vaccinations. And if you refuse, the fines range from $100,000 to $500,000, depending upon circumstances, which of course I encourage everyone to read the entire rule to know the circumstances. But here's something else. Additionally, the person will be charged for the treatment, including room and board costs. And then if or when you are released, there will be two types of release. One is a conditional release. The other is an electronic or internet-based monitoring. Now, folks, this talks to me like we're talking, pardon the expression, FEMA camps.
Sounds FEMA-ish to me. Febrile, FEMA, extermination, tyranny. I don't know. They all seem to me to be in the same mix here. What do you guys think?
Let me explain this. In 1946, America was being confronted with all these agencies that had been given rulemaking authority by Congress. And some of these regulations would implement the law, but other parts of the regulation would only simply interpret the law. Now, in 1946, Congress came out with the Administrative Procedures Act. It requires, what we're going through right now with this regulation. Now an agency, when it's getting ready to come out with a new regulation, must submit it to the public for comment. And usually most of these regulations are going to be seen as people that are concerned should make a comment. I'll give you an example. The comments got up to more than 200,000, and the agency withdrew. So there's a reason why people need to at least sit down and when a set of regulations is being proposed for comment. Well, we have right now this set of regulations. It must be subjected to criticism by those that are concerned about it. Then the agency's going to have to deal with it. And after they deal with it, they'll come out with a final set of regulations that have got to be published in the Federal Register. And after it's published in the Federal Register, it'll ultimately make it into the Code of Federal Regulations. Even if you have a regulation that's been adopted, there is still the opportunity to complain about it later on. But at that stage, when you're complaining about it, it's going to involve litigation.
When I read the same document, it seemed to me that the entire point of this was that 100% of the power rests in the CDC's hands under the proposed regulations, and nothing like informed consent or any kind of redress was
I agree with you, Rima.
made available or was hinted at. Now, there may be an underpinning in law that no regulation or law can take away, but most people wouldn't know about it.
We actually have a web form to do that, and that web form is at tinyurl.com/informed consent protection. It's a form that automatically sends those messages for people. And yes, we've proven over and over again, Larry, that pushback works. And of course, it is a requirement of the Administrative Procedures Act. The agency simply can't proclaim a regulation. First, they have to propose it. Then they have, as you know, then they have to allow for public comments. And then they finalize the regulation responding to comments. Now, sometimes they don't respond to the most important comments, but as Larry points out, since we filed a formal objection, we could be a plaintiff in attacking the regulation if it is approved. Back in 2007, we had 500,000 people flood the FDA with objections to their so-called CAM guidance, which would have created a new regulatory category without bothering to ask Congress, and they never finalized that regulation. It was never finalized. So yes.
And the guy who wrote it commented. Actually, it was 688,000 comments through our action item, which crashed the FDA website, which made me very happy. And the guy who wrote the regulation commented in response to all of these negative evaluations of his work. Well, after all, I'm not Darth Vader. Well,
Right.
yes, actually, he was trying to be Darth Vader.
But I just see too many federal agencies are really been established to deal with laws, enforce laws. This is a redeeming principle that I see. The sovereignty, power, and jurisdiction of the United States is primarily external to this country, and I just see too many federal agencies really only having, that kind of an external look. And I think the CDC is one of those agencies.
I'd like to remind people that one way of asserting your informed consent right is to do so as Dr. Rima did with General Burt by writing it on the consent forms or by carrying with you an advanced medical directive card or two.
And I have with me in my wallet General Burt's advanced medical directive card and mine.
Right.
I wrote this on the forms, all vaccines refused, expecting to have to pull out my card. And what happened was people said, "Oh, okay,"
because they know it's the law. And
exactly.
People regularly carry I am a diabetic cards. I know some Jehovah's Witnesses who carry cards that say I refuse all transfusions. And of course, you can obtain your advanced vaccine directive card from Natural Solutions Foundation, AVD card, AVD, Advanced Vaccine Directive. Dr. Rima, let's bring our guests back.
Go ahead, Catherine.
I would like to take us further down the rabbit hole. Can I do that?
Okay.
Sure.
Okay. United States Code Title 42, the Public Health and Welfare. And I have a 3-page printout here when I was doing my research into this mammoth thing that I think may put a different spin on things, if I may be so brash as to introduce this. Chapter 6A, Public Health Service, General Powers and Duties, Part G, Quarantine and Inspection, Section 264, Regulations to Control Communicable Diseases, Apprehension, Detention, or Conditional Release of Individuals, Application of regulations to persons entering from foreign countries, blah, 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 blah. It goes on. But the thing that I want to specifically point out in Section 264B, Apprehension, Detention, blah, 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 that it says regulations prescribed under this section shall not provide for the apprehension, detention, or conditional release of individuals except for the purpose of preventing the introduction, transmission, or spread of such communicable diseases as may be specified from time to time in executive orders of the President upon the recommendation of the Secretary in consultation with the Surgeon General. Interesting?
Indeed.
I have in front of me the Executive Order 12 of 452 that was issued in 1983 and changed with the Executive Order 13295 in 2005 by Bush, and it goes on to define things a little differently, which is very interesting. So this is why I brought this into the discussion, because it is my opinion, unless we address this in our comments, we may be missing something rather important.
Now, I would very much like to have your response to what Catherine's just brought up, Larry.
Well, I've looked at executive orders for years. One of the first executive orders to come out was George Washington's executive order. Didn't have any statutory authority. I just want there to be Thanksgiving. And ever since then, presidents have come out with their annual proclamation of Thanksgiving. There's no statutory foundation for that. When you see, president make something that's overreaching, therein's going to be your defense when the problem comes up.
Why would very ominous sounding provisions be promulgated in executive orders? And if you read them, they're very scary. They say the president can, for example, commandeer anything in the country in times of national need. And then it goes on and on and on and on.
You're referencing those executive orders issued by President Kennedy that in the time of emergency, they'll seize this, that, and the other. Is that what you said just a minute ago? Were you referring to those JFK executive orders to seize everything?
I am, but I'm also referring, and Catherine may be able to cite the specific items. I'm also referring to some by Bush and a fair number by Obama that say essentially the same thing in one way or another. And it could be in time of communicable disease. It could be in time of national emergency. It could be in time of unspecified disaster. Catherine, can you pull any out of your
I have them here.
archive?
I have them exactly here. Here they are. The 4 presidential executive orders dealing with communicable diseases are these. PEO 12452, dated December 22, 1983, President Ronald Reagan. PEO 13295, dated April 4, 2003, President George W. Bush. PEO 13375, dated August 1, 2005, President George W. Bush. PEO 13674, July 31, 2014, President Barack Obama. Those are the ones that are specific, but within the body of this proposed rule that CDC is overreaching with, they have cited several others as their bases for empowerment. I have looked at so many and read so many of President Obama's PEOs that in each one he specifically has cited, by the power given to me by the Constitution, I can do this. Now, there is no power given to him by the Constitution.
Absolutely not. And that's the reason why I brought up the steel seizure cases. People need to know about this. Catherine, you're probably going through what a lot of people in this movement do. They read these executive orders and, wow, the president without understanding the legal context of it. The president
I think I do understand the legal context of it, because I'm saying they're basically BS. He has no constitutional right to do this.
Absolutely, and the authority for that is the steel seizure cases. He can't just come out and say, I'm going to seize all these people. There is no inherent authority on the part of the president. The only constitutional authority that he has is the authority to execute the laws of Congress.
We also filed a formal comment in the CDC's own comment system because, of course, again, that Administrative Procedures Act tells us how we have to proceed. And I think, Larry, what I took from one of your comments earlier is maybe if you want to challenge one of these regulations, you must file a comment at this stage. This is part of exhausting your administrative remedies. So it's important for us to assert our informed consent or lack thereof. We need to assert it in the administrative process. We need to assert it when we go into a hospital and sign consent forms. The whole point of this regulation, and when you look at the actual regulation and you look to where they talk about consent, the whole structure of the regulation is to override informed consent. And that's why it is
actually
so
deny
dangerous. Yeah, right, exactly.
It's actually a denial of informed consent, as opposed to overriding.
It's more than a denial. It cancels it. It says we're going to make an agreement with the individual, but the individual's consent or agreement to agree is irrelevant.
That's correct.
The agreement is we agree with ourselves, and what you say doesn't matter. Now, I would like to point out that we've been talking about some very, very important underpinnings of the reality of this event, this attempt to take power in a particular way. But what we haven't emphasized is that you can do something about it. Ralph mentioned it, but I want to circle back to it. Whenever we, in our righteous wrath and indignation, rise up and say the same thing to one of these federal agencies or state agencies, if we are sufficient in our clarity and in our numbers, numbers are critically important here, then each and every time the agency, the person, the regulation is pushed back. But if you say, well, let somebody else do it, or I'll take the action, but I'm not going to spend 10 minutes or 20 minutes sharing it on my social media with the contacts that I have who might be interested in protecting their freedom, their children, their lives, their immune systems, and so on, then we will not succeed. So it depends on you. It depends on you remembering that there is a dirty little secret to globalist destruction of our freedoms and our rights and our awareness that we have rights, which is necessary before you can exercise a right. And that is, they want you to feel isolated. They want you to feel impotent. They want you to feel as if it's all too big for little old you. You are not isolated. You are not impotent. And it is by no means too big and too complex for little old you. So we urge you with all the strength that we can muster to do what Larry said, to take action. And you do that by going to tinyurl.com/informed consent protection. It can't get any simpler than that. You go there, you read it, you click one button, you fill in your identifying data, which is, of course, kept private. You click submit. Your state legislators, your governor, your federal legislators, your head of HHS, Health and Human Services, the president, all of them get your email when you click one time. I call it riding the freedom mouse.
You know, the official summary, as I read earlier, says this is a notice of proposed rulemaking. It is amending its domestic, interstate, and foreign quarantine regulations to, quote, best protect the public health of the United States.
Well, this has been a very interesting program. I've gotten a lot out of it. I'm glad to meet Catherine.
Likewise. I think, amongst the four of us, we've got more brains than maybe the whole CDC. Or am I saying that?
Well, we've all been appearing on each other's radio programs over the years, and you've really taken us down some interesting rabbit holes tonight.
Indeed. This has been a wonderful show. Thank you all. Folks, you have been listening to the Dr. Rima Truth Reports with Dr. Rima Ilebo, MD, Ralph Fusatola, JD, our two amazing guests, Catherine Frompovich and Larry B. Kraft. Please go to www.drrimatruthreports.com and put your name in the email slot so that we can send you our free newsletter and keep you updated on this and other fascinating and vital areas wherein your health and your health freedom lie. Thank you so much for being with us.